products thereof. The Cartagena Protocol on Biosafety do not excludes in its coverage the product thereof. Okay? Meaning, the Cartagena Protocol regulates the transboundary movement, the transit, the use, and the handle of living modified organisms. But Cartagena excludes in its coverage the product thereof. What are the products? Like for example, the sausage, or the cereal, or the chips, which contains GMO. Cartagena Protocol cannot be used to invoke certain rights because it excludes products. So the TWO on Model Biosafety covers both LMO and products. So the third aspect is the labeling. So this is to ensure that the consumer's right to safe food will be guaranteed. So it is upon the consumers whether or not they will buy GM products or not. The fourth is the mandatory public participation. Public participation in two levels. First, on the development of biosafety regulations. Second, on the release of GMO to the environment. So the public in general should be consulted on what are the necessary biosafety regulations should the state institute. Plus, the public in general should be consulted on whether or not certain GMO will be released to the environment. Public participation in the sense that there will be an active interaction between the proponent, the industry, and the public. So the public will be, it's like the setup in the trial court. Okay, the industry should be asked to present evidence, witness, that will justify the safety of their product that will be released in the environment. The next is the environmental impact assessment. Okay, so the industry should be required to have to present environmental impact assessment based on the guidelines that the government should or will develop. The next is the socio-economic impact assessment. So this is in relation to the farmers' rights that were mentioned a while ago by Shalini, respecting the rights of the rights of the farmer to save seed, to seed exchange, to market, etc. So the socio-economic impact assessment should be the measuring guide whether the entry of GMO to the release of GMO to the environment will violate the rights of the farmers. The next is the transparency, provision and transparency. So whatever the decision that the government should make in relation to the application, the entry of GMO to the country or release to the environment should be known to the public. And lastly, the liability and redress. Assuming that the industry was able to surpass all the requirements that the government has been asking, so they will release now the GMO to the environment. The next question is, who will be liable, or what will be the liability of the company in case of damage because of that release of GMO to the environment? So who will be liable to the decrease of income of the organic farmers, wherein their produce has been contaminated by GM seeds? Who will be liable to the issue of contamination, etc. The GMO will cause diseases, allergy, cause death to the people who will be liable. So the issue of liability and the provision on redress, like what has been mentioned, the cleaning up, the restoration, etc. So that are the different provisions developed by TWN as a model biosafety law based on the different provisions of Cartagena Protocol on Biosafety.
Thank you, Vishwa. Any questions? Topics health effects. And then they test and say no impacts on beneficial organisms or whatever. And they start because their testing framework includes only a few narrow parameters of whether it is safe in the defined parameters, right? And BT cotton, after it's come in, it's been using so much of chemical fertilizers that the soil is slowly dying. There's been an impact also related to BT toxins impacting the, let's say, the soil microbial organisms. There's been some studies of that sort also. So in the narrow testing framework, something might pass as safe, but then that may leave impacts for the next generation, having certain resources or not having certain resources, things like that. So I'm essentially saying that how much resources get utilized in which way for this generation's, defined development goals, as opposed to, what we leave behind.
Ma'am, one question is in my mind. There is a concept regarding social corporate responsibility. So, is there any law regarding which makes mandatory that there must be corporate social responsibility under these guidelines? And this type of social corporate responsibility must be there.
That's, I think, completely unconnected to this. This is about liability. Why corporate social responsibility is something one wears on their sleeve to show we are also good people. But we're talking about liability for what you're taking up. Are you responsible? Do you know that this is conclusively safe? How are you saying that it is safe? Show proof. Followed by, if things go wrong, are you liable? I think it's a far...
Liability comes when wrong happens. But when corporate enters into the market, it means it is having all benefits from the society. So there must be duty of the corporate to give something to the society also.
That is, that I think has got nothing to do with governing GMOs, whether they should come in, when they should come in, how they should come in. If somebody is arguing for responsibility towards society, I think that's a completely different subject. You wanted to add something, Kanchi?
No, I just want to say that, when you said this point about corporate liability comes when something wrong occurs. All that is being shared here is that the way in which a certain product is brought into the market, that process has a serious flaw. Okay? And if the process has serious flaws, this conflict of interest, assessments are not happened. So basically there are other interests, political, scientific, whatever it is, that has made that product reach the market when it is actually not safe. So you are willy-nilly actually introducing something in the market which might be wrong. Now in that instance, there is not social responsibility. Your responsibility has been violated the moment you brought it in. So you are liable to the fact that that product actually is wrong.
It means liability comes before responsibility.
No, responsibility should come before liability. I should be responsible that I don't enter that product in the market in the first place. But corporate social responsibility in a very superficial or whatever the way it's been used is basically I'll do good after I get all the profits. So I get all the profits and then I do.
And what type of framework is in place in countries like US and EU regarding these GM foods?
Well, the US is pretty bad. They have a system of asking the crop producers to just declare their product to be safe. They follow a principle that's where you can brand your product as GRAS, generally regarded as safe. This is more or less equivalent to the non-GM counterpart, therefore I am writing this thing. At the most, the US EPA asked for a couple of tests, but the US FDA is very, very lax on this. So US is not a model for us to emulate on this at all, like in several other cases, I would think. The EU, at the EU level, the EFSA, European Food Standards Authority, has also played to the interest of the industry in recommending certain things, but luckily for them, they then have national legislation. And the Austrian legislation that she's talking about, the Norwegian legislation that I am talking about, these are the ones which are really good. If we want to emulate them, if we want to pick up good ideal components, we should take it from there. And then there are other countries like in Australia, for instance, Western Australia and Tasmania have a ban. they do a state level, even though the neighbors are growing, and more growing GM in other states of Australia. More and more we find that that's probably a requirement in India, because Kerala wants to be GM free, Orissa wants to be GM free, and the centre may not listen. We may need state level laws to be enacted sooner or later to at least ensure that the state level policy can be implemented through a strategy. Yeah.
I just want to, it's just a comment. See, we keep saying conflict of interest. The word conflict of interest means that the other side, the person who is approving or whatever, in the long run, they are also harm. Is it not? It's not to do with one person or two person. So there's no question of conflict of interest there, in the sense that at the outside maybe they are about corruption or whatever, but there is no really, their interest also suffers, is it not?
No, in fact,
How do we put
precisely
that
for that
conflict
reason.
of interest?
No, conflicting interest, don't link it just to immediate corruption or an incestuous relationship with someone. No, this is about the fact that if I'm a GM prop developer, if I ask you too many questions now, tomorrow my turn will come where you or the rest of you will ask me too many questions. Everyone wants to go to the same lifetime.
No, what I'm meaning is, see, if somebody approves there is a collaboration with an agricultural university, say. The agricultural, the people experts there may have a better idea of the whole thing than the common man or people like us. In spite of it, they approve, but there is no interest for them, because in the sense, I'm talking in the larger perspective, that there is really no interest, because it is harming to mankind.
No, but I'm telling you, they are all either, several of them are GM prop developers themselves, or come from institutions which want to go through the same process of approval. There are really no independent people out there.
I'm not able to give my thoughts properly.
See, you are right that it is in nobody's enlightened self-interest, even a crop developer, even Monsanto. Suppose I am the chairman of Monsanto. It is not even in my enlightened self-interest to allow a hazardous crop to come into the market, which will sooner or later affect my health as well.
Yes.
But you see, the problem with conflict of interest is that unfortunately people don't see their long-term enlightened self-interest. Many people just see, look, I'm going to make so much money. If I allow this health, the one doesn't know, it's uncertain, it may affect, may not affect me, I will not consume it, but at least I will make so much money. So, that is why we say that if there is any other interest created in that person, apart from pure public interest, which can make many people inclined to take the influenced by your telling them. Unfortunately, the nature of the corporation today, the bottom line is the only objective. That is, profits are the only objective. That has become the whole nature of corporate business. That a person who is in charge of a company is only judged from how much profit he makes for that company. That's become the whole structure of the corporation. I think that's a serious problem which needs to be discussed with the world.
Imran, at this point, can we take a break? See whether it's being implemented. The law says something, and what is happening on the ground in real time is another story. Kanchi will walk us through that journey, and she will also point out some of the relevant provisions from the point of view of biosafety. So, in terms of organizing our day, it's 4 o'clock now. Let's try and end the day by a little past 5. We give Kanchi some space to talk, and then we can open it up. And also not only pose questions to her, but also just reflect over some of the issues that came from the presentations throughout the day. And so we should wrap, I think, latest by 5:30, if that's okay with everybody. Yes? Okay. Kanchi, over to you.
Okay. Should I use Hindi English mix?
Yeah.
As Charlie said, long day. I don't know how much of what I'm going to say I'll be able to say well because it's a long day, and how much I'll be able to say you all will grasp. But मैं कोशिश करती हूँ कि दो बातों से शुरुआत करनी है. Two things that you all have been discussing from whatever time I have been here. We've dealt a lot with. We've spoken about the word conservation, संरक्षण की बहुत बात की है, and regulation की बहुत बात की है. My fundamental question in this whole thing is that can the two go together? जिस तरह से similarly biodiversity की बात करते हैं, जैव विविधता की बात करते हैं, we talk about biodiversity, and then we talk about biotechnology, which is basically monoculture, a mono way of looking, not a diverse way of looking at something. Can the two go together? Now, since all of you are from the law fraternity, you all know that, especially in the environment sector, law has evolved at different stages. Law was conservation law. Firstly, there was a whole set of law that came in that was talking about Wildlife Protection Act, Environment Protection Act, it spoke about protection, Forest Conservation Act. Then came a stage that everybody started talking about regulation. Regulation का main चीज क्या है? It comes at a point. We need to try and understand what point regulation really comes in any process, which all of you I'm sure are aware of. Regulation comes in at a process where you say that a certain situation is given. Murder is given. Murder to hoga. We need to regulate murder. IPRs are given. They are supposed to be here. Intellectual property rights are given. Let's see the best possible way somebody can get intellectual property rights and whose property they are taking. Let's give उसको थोड़े पैसे दे देंगे या उसको अधिकार दे देंगे या कुछ कर लेंगे. So it starts at a point. Any regulation will start at the point where you will say that something is given. Similarly with the Biological Diversity Act, जब वो आया शुरुआत में तो बहुत it spoke a lot about conservation. शुरुआत में बहुत संरक्षण की बात हुई. But by the time it came in, it kind of brought together a regulatory system. A regulatory system which said access to biological material, चाहे वो GM के लिए हो, whether it is for genetic modification or for wildlife research or for everything, it is given, it is here to stay. So let's see how best possible we can regulate it. Let's make it difficult for the people to regulate it. And by the time this law came, the third phase of law actually entered, which is the compensatory regime. They said that okay, we are talking about conservation, we are talking about regulation, and when we are regulating it, let's make sure that this company pays us the best possible price for the material that they give. जब ये कंपनी ले रही है हमसे जो भी हमारा अधिकार ले रही है, इंटेलेक्चुअल प्रॉपर्टी ले रही है, कोई मटेरियल ले रही है रिसर्च के लिए या कोई साइंटिफिक इंस्टीट्यूशन ले रही है, लेट अस टेल देम, उनको बोलना चाहिए कि हम ये आपको किसी कीमत में मिलेगा और जिनका अधिकार आप ले रहे हो उस कीमत से लेके जाए. So we have reached these three phases. Currently we are in this combination of regulation and compensation. And that is why when we talk about any new law that is coming in, any new law that comes in, can conservation and regulation go together? That is something we need to think of, because after every training, after every session, we said there is not enough robust law here to protect us. So can any law say this will be for protection of biodiversity and regulation of biosafety or biotechnology? Can the two actually blend? And that's a question I think many people are dealing with currently. उसमें बहुत short term, long term debate हो जाती है, which we can probably get into it a little later. But so giving this as a premise, giving this as somebody who has, I didn't start as being a lawyer, but because in activism you tend to deal with a lot with law and how law is implemented, you tend to go deeper into it. And why is it that these regimes are, whether it is the National Genetic Engineering Appraisal Committee, whether it is the biodiversity law, why is it that the same patterns are being replicated? वही चीज हम बोलते हैं, हर law. So anyway, coming back to the Biological Diversity Act. When initially, in the late 80s and 90s, when we are talking about conservation and protection being the primary emphasis of law, 70s, 80s, that time it was being argued that there is no particular law for biodiversity. For instance, currently it is being argued that there is no law to regulate biotechnology. At that point of time, there was being argued there is no law to conserve biodiversity per se. Environment Protection Act is there, separately वो है. Wildlife Protection Act separately है, Forest Conservation Act separately है, but something that looks at biological material, we do not have that. Okay, till then, every biological material that was being taken was technically illegal. But we brought in a law in the name of conservation, and then we'll see what happens. So there was a law that was argued that was needed for conserving India's rich biodiversity and associated traditional knowledge. Lot of international processes काफी चल रहे थे at that point of time, which had also influenced some of this thinking. The second objective is that we need a law that will restrict and control biodiversity. So exactly the kind of arguments we were doing, earlier about biotechnology. It has to be proactive protection of areas rich for biodiversity. So we have agriculture related biodiversity a lot in the country. We have wild areas which are rich in diverse species. We need to proactively go and protect it, before something else happens to it. That gene pool or whatever needs to be protected. It is also a certain guardianship for living diversity. And जो लोगों की पारंपरिक सोच है, उनका पारंपरिक ज्ञान है, किस तरह से उसका संरक्षण किया जाए. और जो सरकार है या हम जैसे एक्टिविस्ट हैं या लॉयर्स हैं जो सोशली काम करते हैं, how is it that they can come forward and say these are the real custodians of biodiversity and protect the living diversity, wisdoms and livelihoods related. And the whole thinking that you need to hold responsible the existing governance towards conservation. So conservation was at that point in time a predominant thing. Any point? Just talk.
What do you mean by the term biopiracy?
That's your point.
Biopiracy means theft, right? Or copying or replicating. Biopiracy was when your neem and your basmati and your turmeric, somebody else is taking a patent, claiming that it is their invention. They have pirated it from your country or the local community, repackaged it, and are then selling it back to you, saying, this is our product. So the person who's buying it can scream, ये तो मेरे ज्ञान की चोरी है, ये तो मेरे स्थानीय ज्ञान और जो समुदाय में जो धरोहर था उसकी चोरी है. How can you suddenly claim like a multinational from the US saying called W.R. Grace filed a patent application before the EPO, the European Patent Office in Germany, on the pesticidal qualities of neem. Now, neem has been used in all our households, our grandmothers, दातुन के लिए इस्तेमाल अभी भी होता है गाँव में. और जो नीम के पत्ते हैं, when we save seeds, we use the neem leaves, and also the juice from the neem tree is used biopesticides in organic farming by farmers. This has been a traditional practice because that knowledge has been there in our communities. जब उसको एक पेटेंट सिस्टम के द्वारा IPR देकर उस पे हक जताया जाता है, उस पेटेंट लाइसेंस से, it means it is resulting in biopiracy. It's a theft, it's a piracy. But because it refers to biological resources and because it refers to biological knowledge, it's called biopiracy.
So, ma'am, basically this term of international context it can be used.
Yes, it is used also. It has come from an international
So,
context.
is there any international law that got the national on this?
The Convention on Biological Diversity, which came into being in 1993 after the Rio Summit in 1992, that is the same summit, the Earth Summit, where the Climate Change Convention and the Biological Diversity Convention were finalized and agreed by countries. Now, India also signed on to the CBD. And it is there, the CBD actually came into being because countries in the south, which are rich in biological resources and traditional knowledge, were saying, stop pirating our traditional knowledge, stop using our biological resources without our permission. Because the developed countries which have the technology but don't have the resources were accessing resources from the south, processing it, making products, selling it back to you. So that's why the CBD was supposed to be an international legal instrument by which justice and balance in this access of genetic resources could be attained. But we'll see if that has been possible through the CBD or whether the Convention on Biological Diversity has also become a forum for trade.
Okay. As I said, there was a lot of international processes that also led to India's biodiversity law. So, as Shalini was talking about, on 5th June 1992 was the Convention on Biological Diversity. This is just to give you a trajectory, where is this law really coming from? Other than the fact that India may be काफी efforts हो रहे थे, there was an international influence that led to the coming in of this law. A lot of this is in the publications which were kept there, so you should find it there. India ratified it. Uske baad chala that after that the process to actually draft India's law, Biodiversity Act really started. 97, 98. We spoke about M.S. Swaminathan. He was the key member of the task force even here. Under him there was a 16-member committee set up हुई थी, जिन्होंने initially जो Biodiversity Act का ढांचा था, the structure of the Biological Diversity Act actually was a procedure for access. So if somebody needs to access biological material for genetic modification, for wildlife research, for commercial utilization, for whatever else, for production of ethanol now, you need to follow a process. The moment you follow a process, then if you don't follow it, it is biopiracy. If you follow it, then it's legalized piracy, whatever. So anyway, there was a lot of intervention in that procedure for access and a lot of clauses for conservation, संरक्षण के काफी प्रावधान उसमें डाले गए, and which I'll talk about later. Vis-a-vis GM, there are a few which I'll talk about. So it was basically initially a access legislation, which was a lot of people argued saying that you need to strengthen the whole conservation portion of it. And there's again a trajectory how when the bill came in, and finally the act was notified, and 2004 the rules were notified. And following that, it's been now 7 years since we've had the act, and I'll just talk about what it really envisages. When it was finally notified, there were three objectives of the law, lifting it straight from the Convention on Biological Diversity. The conservation of biodiversity, संरक्षण, जैव विविधता का संरक्षण, sustainable use. So it kind of presupposed that use will be there, whether it is by communities, or it is by corporations, or it is by research institutions. Use of biological material is going to be there. You just added the element of sustainable use. And the way I might define sustainable is a very different way that somebody else might define sustainable. So that sustainable use of biological resources came in. And it also brought in an element that when the use takes place, and it takes place for commercial use, then you need to have equity, a responsible, equal distribution of the benefits that arise. So if I take somebody's knowledge or a certain species where some community has a knowledge, and I make up medicine out of it and I sell it in the market, then I need to share the benefits of whatever I earn. जो भी मैं उससे मेरा profit होगा, उसके benefits मुझे share करना. So these three objectives of the Biological Diversity Act were set in place. Very broadly, I will not go into details because that itself will take an hour in terms of what really the Biological Diversity Act contains. But in its institutional structure, what is important for us to understand is Biological Diversity Act, okay, we will be looking at access vis-a-vis GM much more closely later on.